All rise. This Chancery Court of Dickson County is now in session. The Honorable Judge David Wolf presiding. All ye having business before this court, for all nine ye shall be heard. God bless the United States, this state, and this court. Seated.
I left it out when I gave you back the file. All right, good morning. This is the day after Memorial Day, and I don't know how many of you have actually observed anything about Memorial Day, but it is a significant day for those of us who have family that served in the military and maybe have lost loved ones serving in the military. And it occurred to me that too often we take these things, these rights and privileges that we have for granted. Over the weekend and yesterday, I was watching a Netflix show that was about Lincoln, and in it they recreated the Gettysburg Address. And it hit me that that is one of the most important speeches, 272 words, that our country has ever experienced. And in this day and age, with the divisions and animosity that's being expressed towards citizen to citizen, I think it's important that we remember what Lincoln had to say. So I'm going to read this. You bear with me. This was delivered at the dedication of the Soldiers' National Cemetery at Gettysburg, Pennsylvania. 77 years ago, our fathers brought forth on this continent a new nation, conceived in liberty and dedicated to the proposition that all men are created equal. Now we are engaged in a great civil war, testing whether that nation or any nation so conceived and so dedicated can long endure. We are met on a great battlefield of that war. We have come to dedicate a portion of that field as a final resting place for those who gave their lives that that nation might live. It is altogether fitting and proper that we should do this. But in a larger sense, we cannot dedicate, we cannot consecrate, we cannot hallow this ground. The brave men, living and dead, who struggled here have consecrated it, far above our poor power to add to or detract. The world will little note nor long remember what we say here, but it can never forget what they did here. It is for us, the living, rather to be dedicated here to the unfinished work which they who fought here have thus far so nobly advanced. It is rather for us to be here dedicated to the great task remaining before us, that from these honored dead we take increased devotion to that cause for which they gave the last full measure of devotion, that we here highly resolve that these dead shall not have died in vain, that this nation under God shall have a new birth of freedom, and that the government of the people, by the people and for the people, shall not perish from the earth. Abraham Lincoln, November 19th, 1863. If you will stand with me, we're going to have the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you for that. All right, we're ready to start the docket. Call the first case. Good morning. Well, I have 5 people in the room. Who is your client? Who? All right, I've got an Emily, so we'll admit Emily and see if that's the right Emily. If this is Emily Halliburton that's in the meeting now, if you will turn on your, there we go. Are you Emily Halliburton?
I am.
All right. All those who are going to testify, raise your right hand, and that includes you, Ms. Halliburton. All right. You may proceed, Mr.
Yes, Your Honor.
Sanders.
Your Honor, this is a termination of parental rights and adoption, and we are here today on a default following service by publication. So
All right.
we're ready to proceed. Please state your name.
Danelle Cochran.
And Ms. Cochran, you live here in Dickson County, is that correct? And do you know this young lady here between us?
This is my daughter McKinley.
Okay. Tell the court briefly how she came into your life.
McKinley and her brother came to me via foster care. They exited custody under the SPG. I've had her as my ward since April of 2024.
And you have filed with this court a petition to terminate parental rights and for adoption, is that correct? Is the information contained in that true?
Yes.
Ms. Jagger's mother's parental rights were already terminated, is that correct? And we're here today on her biological father. When is the last time that her biological father has had visitation with her?
It's been 3 years.
And has he ever paid any support to her while she was with you? No. Has he made any efforts or attempted to visit, filed anything with the court? Has he shown the court that he has a suitable home or a life that would be fitting to take care of a minor child? Ms. Halliburton, you heard those questions that I asked. Were all of the
Okay.
answers given, were those all true?
They are true.
You agree with all of those?
I do.
And do you think termination of parental rights would be in McKinley's best interest?
I do.
I forgot to ask you, Ms. Cochran, do you likewise think termination would be in the best interest? That's all I have on the termination.
All right. And I find by clear and convincing evidence that the defendant in the case, John Wesley Yeagers, has failed to provide support or failed to exercise visitation, and by the statutory definition, he has abandoned the minor child. You may now proceed with the adoption portions.
Again, Ms. Cochran, would you please state your name?
Danelle Cochran.
And you have filed with this court a petition seeking to adopt McKinley Brooke Jaggers as your child, correct? Is all the information in that petition correct? Are you able to take care of her? You understand that if this court grants this adoption, it will be just like she was born to you. You would have all the responsibilities of a biological parent as far as Ms. McKinley is concerned. You understand that? And you want the court to approve that, and you think that is in her best interest. Ms. Halliburton, same questions for you. You understand that if the court were to grant this adoption, it would be just like she was born to you.
Yes.
You have all the rights and responsibilities of a biological parent, and you want the court to adopt that. Grant
Yes.
adoption.
Yes.
Ms. McKinley, how old are you?
I'm
15. And you understand why we're here today? You want the court to approve this, is that correct? And I asked you about changing your name to anything in the world that you wanted to change it to today, and it's not something you're interested in, right?
No, sir.
Okay, all right. That's all I have, Your Honor.
All right. We'll start with Ms. Cochran. Ms. Cochran, you understand that, as Mr. Sanders has pointed out, this is going to forever change the nature of your relationship with McKinley, and that no longer will you be a foster parent or a guardian. You're going to actually be her mother, the same as if she was born to you biologically, and that carries a lot of responsibilities, duties, and obligations. If, God forbid, something happened between you and your wife, then each of you would have the opportunity to pursue custody and support from the other, and you would have all of the same responsibilities that a biological parent has.
Sure.
Ms. Halliburton, you've heard me ask those questions. Are you aware that this is changing the nature of your relationship and that you are going to be this child's mother the same as if you were the biological parent?
I do. I am aware.
Both of you are willing to assume that. You have a teenager already. She's 15, but she's just beginning to be a teenager, so McKinley looks like a really nice young lady. I'm sure she will never give you a minute's worry or anything that will cause you to be concerned about staying out late or doing anything that she shouldn't do. And when she starts dating guys, she will only date those guys that you find to be appropriate or whatever the situation may be. In any event, you understand that this is going to be your responsibility to ensure that she's nurtured and guided through her teenage years. You understand that? Ms. Halliburton, you understand that?
I do.
All right. I find that this adoption is in McKinley's best interest as well. McKinley, you got anything else you want to say? Now's your time. This is one time you can say anything you want to about your parents without any ramifications. So now is to speak. Speak now or forever hold your peace. All right. Then I will sign your order and grant your adoptions.
May we take a photograph, Your Honor?
You may.
How do you want them to take the picture, Your Honor?
Doesn't matter to me. We don't have, Ms. Halliburton's not with us except on the screen, so if you want to, I'll step down here and you can
Okay,
take a
try to get in front
picture.
of the screen.
Yes. Thank you, Ms. Halliburton.
Thank you.
All right, good morning.
Good morning.
We have with us the petitioners, Ms. Shirley Ponder and Mr. John Hunter. This is a petition for conservatorship of their mother. If we could have them sworn in, please.
All those who are going to testify, raise your right hand. Let's place you under oath.
You are Shirley Ponder?
Yes, sir.
And you are John Hunter? And you are the two biological children of Miss Dorothy Hunter, is that correct?
Yes.
Now, you two have asked me to file a petition to have the two of you appointed as Miss Hunter's conservator, is that correct?
Yes.
And just confirming for the record, Miss Hunter is 92 years old, is that correct? And in connection with this petition, did Miss Hunter receive treatment, and did she meet with a physician by the name of Dr. Benjamin DeHaven?
Yes.
And did Dr. DeHaven file a report outlining what her current medical condition is? Specifically, that Ms. Hunter suffers from arthritis, heart failure, memory loss, and cognitive decline. And you two have taken care of her informally for quite some time, is that correct? And given the health issues that she's experiencing, worsening condition both physically and mentally, you feel at this time it is appropriate to ask the court to have the two of you appointed as her conservator, is that correct? You have also, in connection with this petition, coordinated with my office to prepare a property management plan. You all currently have Ms. Hunter's real estate listed with Mr. Neil Trice, is that correct? Included with the real estate, she also has bank accounts, CDs, stocks, which you all intend to utilize for her care to pay for her medical expenses and her day-to-day living expenses, is that correct? One other thing you mentioned to me, subsequent to the filing of this petition, I think Ms. Hunter has experienced 1 or 2 falls, is that correct?
She's had 3.
3 falls, okay. And so based on that, I think she's currently or in the process of transitioning from Olive Branch to the Pearl at Fairview, is that correct? You all believe that she can receive better care and attention at that facility, and so that would justify the move to that care facility. You all believe that this is in the best interest of Ms. Hunter? Your Honor, Mr. Brown has filed a guardian ad litem report, I believe also recommending that the appointment is in order. And if the court has any questions for the petitioners or Mr. Brown, happy to entertain those.
Mr. Brown, I've read your report. Anything you want to add to it? All right. Ms. Hunter is lucky to have the two of you to take care of, and too often we see parents whose children basically abandon them when they get to be in need. So I'm very happy that the two of you have stepped up and taken care of your mother. I am happy to grant your petition for appointment of co-conservators. Is that what we're doing?
Yes, sir.
All right. Then I will grant your order. You say there is an order?
There should be one tendered in the file, Judge.
Mr. Brown, if you want to submit your fee application, I'll be glad to. I've signed your order. Thank you.
Judge.
Anyone here to prosecute the claim of Horizon Medical Center? No one here to prosecute your claim. The claim, the exception is granted.
Thank you, Your Honor. We'll tender an order.
All right, we have someone on Zoom that's Jill Carpenter. I'm not sure which. All right, I am looking for Jill Carpenter or someone on behalf of Jill Carpenter on a motion for substitution of counsel.
Yes, Your Honor. Attorney Williams on behalf of Ms. Carpenter.
All right, thank you. You are substituting, Ms. Williams is going to be substituting, I'm sorry, Ms. Carpenter is going to be substituting for Mr. Rob Turner, is that correct?
That is correct, Your Honor.
And if you will submit an order, I'll be glad to sign off on it, so.
Will do.
All right, submit your order, please.
I have another one before you as well. I don't know if you're going in a particular order.
Oh. This is a motion to waive mediation.
Yes, sir.
I've read through your motion. I don't have any opposition to waiving a mediation, but how quickly are you wanting to have this case set for hearing?
We'd like to move it forward as quickly as possible. The respondent or the defendant is having medical health issues. He's been transferred or moved to California. And so my client would like to get divorced as soon as possible before something unexpected happens. So if we can get it, we'd like to come back for a date within the next 30 to 60 days.
You want to give her a date? Let's see if we give her a date. The defendant is not represented, is that correct?
That's correct.
July the 1st.
At what time?
What?
Would it be at 9 a.m.?
9 o'clock.
All right. We'll take that, Your Honor.
All right, thank you.
Thank you so much.
Good morning. I hate to be the bearer of bad news, but the law in the state of Tennessee requires that you file a sworn or verified complaint for divorce. The copy that I have in this court file bears the signature of Nicole Merritt, and on the second page it has, again, Nicole Merritt with an address and telephone number and an email address, but there is no affidavit, no sworn, it was not sworn to, and therefore it's, in the eyes of the law, a nullity. You have to file a sworn complaint for divorce, a verified or sworn complaint. It has to be signed in front of a notary so that all of the allegations in the complaint are sworn to. So I'm not dismissing this case, but I'm just advising you that you're going to have to file an amended complaint to obtain a divorce that complies with all of the statutory requirements. And it will have to be verified too.
Thank you, Your Honor.
Thank you. All right, any time estimate? All right, let me see what else we have.
That's your competing orders.
See, Your Honor, I'd like to request that this matter not be live streamed.
All right, we'll put you at the tail of the docket then. Have a seat.
Understood, Your Honor.
Good morning.
Happy to report that Ms. Listowka has entered a treatment program. Mr. Holly and I are going to continue these matters and hoping for success at her treatment, and we'll reset these matters by agreement if necessary.
All right. Mr. Hawley, you agree that you're going to pass all your motions?
I am, and partially has motions too to be passed. There's a restraining order in the middle of this. That's all gonna stay where it is in place until we come out.
All right. Let's put down an order that reflects that, if you will, please.
Will do. Yes, sir.
Thank you,
Judge.
Your Honor.
Thank you.
Appreciate it.
Do you want me to put in there about your witnesses? I don't know if they're here.
A lot of witnesses here, but I'll just have to subpoena them again, I guess. Thank you for your time, Your Honor.
You're welcome.
I had another case, Cruz v. Jones, that was another restraining order that was on for today. It's taken off the docket. Miss Henderson had a death in the family. We were working on this before then, but I've tendered some agreed orders for the court on that particular case. I didn't know if Your Honor was covering
All right.
on restraining orders, but that case will need to be reset. Thank you, Judge.
I'm looking for the father's attorney, Rebecca Toka. Anyone in the waiting room that could hear me that would be associated with this case? Have you heard anything from them? Fathers filed a petition to relocate or a notice of relocation. You have filed a petition in opposition to it. And he has filed a response to your petition, so it's going to have to require a hearing for the court, and both sides are entitled to be present. I have not heard from his attorney, so we're going to pass it to the second call to see if we can find out where that lawyer is.
Okay, yes, sir.
Mr. Perricone, this is here on your matter. You have filed a actually a written motion asking for a request for entry of a written order on your motion for intervention, request for service of any agreed restraining order, and a conditional motion to dissolve or declare the ex parte TRO expired. This is a case involving your wife, if you are still married, to Miss Jessie Abigail Baker Perricone, and this case is between her and Mr. Richard Allen Baker. I'm familiar with the situation. I issued a restraining order to restrain Mrs. Perricone from taking the children or having the children have contact with you until we could have a hearing. The basis for that, according to her lawyer, or his lawyer rather, was the fact that there was a Texas court that had entered an order restricting your access to your children. And as a result of that, this court followed the findings of the Texas court, and on a temporary basis for the protection of the children that were involved in this case, issued that order. Two things you need to understand. Number one is you are not a party to this action. I know you filed a motion to intervene, and your argument is that you are entitled to intervene because of the fact that the temporary restraining order affected your ability to have contact with Mrs. Perricone. The second thing is that I am not going to grant your motion to intervene. And Mr. Goebel, are you involved in this case?
Yes, Your Honor. I'm the attorney for the respondent.
Then, under the circumstances, I am willing to give you an opportunity to be heard briefly on this issue, but I'm just telling you that it does not appear to me that you have standing to intervene or that you have the right to intervene in this divorce, in this post-divorce action involving children that are not your children. Do you have anything else you want to say? I know you really wanted an order to be entered, but I'll be glad to hear anything else you have to say within reason.
Was that to me? I'm not sure if I can be heard or not, or was that to Mr. Goebel?
That was to you. It's your motion.
Excellent. Thank you very much, Your Honor. I entered this motion to intervene in a limited scope because the restraint is against my name personally. And it not only infringes upon my liberty personally, but it also infringes upon my son Bodie out of Texas. And so if I'm being declared not a party to the case, but yet I'm refrained by the actual name of the order, then how can that stand? Are you saying that I'm not a party to the case because I'm not married?
You are not a party to this case because this case involves your wife and her former husband, involving their two children. If I understand there's two children, their children, and it is not, you are not a party to it. You are a husband to one of the parties, but that does not give you standing to intervene in this case. The restraining order was not restraining you, it was restraining Mrs. Perricone. And there is a distinct difference between that. You are not being restrained from anything. She is the one who is being restrained.
So there is, even though it lists me by name, if I were to show up to exercise possession time, because I'm no longer married with Miss Baker, if I'm to show up and exercise possession time or be on the phone with, Jessie and her son comes on the phone, I'm not restrained or she's not. You're saying that I'm not restrained, but the order declares and asks her to restrain Mr. Perricone, Christopher M. Perricone. It states me by name that I'm a restrained party.
It mentions you by name only to the effect that Mrs. Perricone, the former Mrs. Baker, is being restrained and directed by the court not to allow contact between her children with Mr. Baker and you. Now, it does not restrain you from anything regarding your child. It simply limits her from having the two children she has, or the child or children she has with Mr. Baker, from having contact with you until there can be a hearing in this court.
Well, the problem is it actually is acting as a restraint upon my possession and possession exchange times with my son Bodie. I know when I was reading through Hogue v. Hogue, it was talking about when an order is vague and not clearly defined. And when I'm listed by name, there's a fear that people that will read the letter of that law and say, if I'm not allowed to be present or have any contact with Miss Baker's children, because Jesse's supposed to restrain me, which I don't know how a private party can restrain my rights. But if I'm going to pick up my son, I'm being restrained. I'm having to adjust my time to pick up for fear that Jesse's kids could be there. And so I'm missing possession time. I'm having to adjust schedules to make the drive up to Tennessee. And it's impacting my time with Bodie even on just phone calls because of Tucker or Gloria there, because my name is specifically mentioned and I would argue that it's a vague order to state that the presence of someone, I don't think that would withstand scrutiny, but I'm being restrained by this, and it's acting as a harsh restraint on the fact of the matter that, where the reality is that it's based upon a Texas order, which is a sealed order. That order never should have even been entered on the public record. It's got even unredacted information on it. And so my name is being restrained. You're ordering Jesse to restrain me based on a Texas order that's contested, that has not even have findings of facts. The harsh parts of that order are omitted in the findings of facts. And a jury trial will be joined.
I am not interested in litigating your Texas situation. All I'm telling you is this doesn't have any application to you and Mrs. Perricone and your child with Mrs. Perricone. This has application only to the children that Mr. Baker and Ms. Perricone have. Mr. Goebel, do you wish to chime in on any of this?
I mean, Your Honor, he's just a former stepfather. I don't believe they're married anymore. He's not the biological father, adopted father, or otherwise legal parent. We just don't believe he has standing in this case between Ms. Baker and Mr. Baker.
Mr. Perricone, I've heard your argument. I've read through your pleadings. I do not find you have a basis under the law or standing under the law to intervene in this action. I do not find that your allegations that this is infringing upon your rights to be meritorious, and as a result of that, I am denying your right to intervene, and an order will be, Mr. Goebel, I'm going to ask you to draw an order and send a copy of it to Mr. Perricone, which sets forth my findings and allows this court to enter an order that shows that, and I want to make it specific, that the restraining order previously entered in this case restrains Mrs. Perricone, the former Mrs. Baker, from having the children around Mr. Perricone. It does not restrain Mr. Perricone from having contact with his minor child with Mrs. Perricone. That's the best I can do for you.
Your Honor, may I make an offer of proof? At least I can present that. I won't have to do it orally to take up time, but can I at least submit an offer of proof to the court?
I'm not going to allow you to make an offer of proof because I do not find you have standing to make an offer of proof.
And
Thank
then
you.
would just like my objection noted for the record then.
All right. Call the next case. Thank you, Mr. Goble. If you'll draw that order, please.
Yes, Your Honor. Thank
My
you.
freaking feet off. Fine, but you do not have standing in this case because you're not. How?
I had a motion, and it was set for Friday. This dude filed some intervening motions.
All right. So everything's set for Friday, the 29th. All right. And that brings us back to your contested case with Mr.
I'm good on the Wagner versus Tyson matter.
Yes.
Ms. Cottonberry is already that part in that matter. She needs to be logged on as a ask.
All right.
I didn't know that.
I don't. Has there been a transcript prepared of this is competing orders from January of this year. We're now in May. Has there been a transcript prepared?
I believe
Well, you're asking, both of you are asking me, and I understand. I'm going to, if you will, mute this. I'm going to mute this, please. I'm muting it. So. versus Mangrum. Yes. Either side wish to make it open. Ms. Coffenberry is now in the waiting room, so I will send her a message. That's fine. That is fine. That's the reason we post the notice if anybody objects. Give me a minute then.